My lords and my ladies, a very quick point before my learned friend continues. Just to say that my instructing solicitor, who works in Leeds and lives near Leeds, I suggested, I hope it's all right that she could not stay, but of course no discourtesy in her not being here. But I just thought I'd mention that fact.
Of course, anyone is free to leave, and particularly her. But thank you for letting me know. Yes, Mr. Kavanagh.
My lords, my lady, excuse me, I'll now like to move, if I may, to Keeley and Fosrock, which you'll find at tab 4 in the authorities panel. You may recall just before the short adjournment that Alexander and STC was a case in which a selection criteria for redundancy were held not to be incorporated into contracts of employment. Keeley is a case about whether a compensation arrangement for redundancy was incorporated or not. It's a decision of this court in which, as I said before the short adjournment, the only judgment is given by Lord Justice Auld, and in this case the Court of Appeal held that the relevant provisions were incorporated. But it's worth just noting what the contract term said and also what the incorporated provision said. The contract term is at paragraph 5. The statement of Mr. Keeley's employment term provided, having said that this statement sets out the main terms of your employment, other relevant information may be found in the company information folders, and other terms and conditions are in your offer letter. The particular provision was in the information folders, and at paragraph 10 we can see what it said. It's only on the 4th page of the document under the 5th heading, compensation, that the document in a 2-sentence described as enhanced redundancy payment provision deals with compensation for redundancy, expressing it in terms of entitlement, but without referring to the method of its calculation or amount, save only to identify the maximum payable tax-free and to indicate that the details were for collective and individual consultation. On the evidence before the judge, the HR manager did not include the redundancy calculation formula in the staff handbook, lest departmental managers erred in calculating individual entitlements, a task to be reserved to the Human Resources Department. That is all the contractual document said about compensation for redundancy. So notwithstanding that, as we will see, this was held to incorporate a right. And perhaps we'll just set out exactly what it says, which is at paragraph 12. Those employees with 2 or more years continuous service are entitled to receive an enhanced redundancy payment from the company, which is paid tax-free to a limit of £30,000. Details will be discussed during both collective and individual consultation. When considering whether this was incorporated, beginning at paragraph 31 on page 966, his lordship notes that something to be incorporated has to be apt for incorporation, and goes on, for example, some provisions read in their context may be declarations of an aspiration or a policy falling short of a contractual undertaking. He then sets out the passage in Alexander I showed you before, at 33. Here, the fact that the staff handbook was presented as a collection of policies does not preclude their having contractual effect, if by their nature and language they are apt to be contractual terms. Pausing there, I make the obvious point that we submit that's applicable in the present case, as clearly many were in the relevant part of Mr. Keeley's handbook, incorporating in that way by reference what was not expressly referred to or detailed in the statement of employment terms. Highly relevant in any consideration, contextual or otherwise, of an incorporated provision in an employment contract is the importance of the provision to the overall bargain. Here, the employer's remuneration package, what he undertook to work for. A provision of that sort, even if couched in terms of information or explanation, or expressed in discretionary terms, may still be apt for construction as a term of his contract, providing it's not in conflict with other contractual provisions. So pausing that, again, that emphasises that one mustn't regard the use of words like guidance and so on, or information, as disqualifying something from having contractual force. Moving on to paragraph 36, with respect to the judge, in paragraph 50 of his judgment, he seems to have overlooked or given insufficient weight to this fundamental starting point in considering the aptness of the enhanced redundancy payment provision in its own right to be a contractual term. If apt by the nature of the subject matter and on its own wording, there is no doubt that it was incorporated by reference, along with other provisions in the staff handbook that were similarly apt. As Lord Justice Dyson noted in the course of Mr. Brennan's submissions, a good way of testing Fosrock's case and the judge's reasoning on construction is to ask whether, and subject to the issue of certainty, if the redundancy policy had been set out in identical terms in Mr. Keeley's statement of employment terms, it could seriously have been argued as a matter of construction that it was not apt for a contractual term and on that account not part of the contract. In Keeley itself, the Court of Appeal found that the term was apt for incorporation. Paragraph 38, His Lordship said the enhanced redundancy...
You don't have to labour that bit, Mr. Cameron. You've only got to look at the term in paragraph 12. How could it not be apt for incorporation?
Well, my Lord, yes, save for this, and the argument I think that was relied upon by Mr. Brennan, QC, which is its sheer vagueness. It doesn't actually say what you qualify for. All it says is you qualify for redundancy payment terms to be negotiated. And as regards that, Lord Justice Auld says at paragraph 40 on the final page of the judgment, even if, which is not contended by Fosrock, the formula and or amount when paid were entirely a matter for its discretion, Hawkellett shows how far the courts will go to give practical effect to the reality of the bargain struck between employer and employee in an exchange of reward for labour as a matter of construction of express terms or by way of implication. And at paragraph 42, and this addresses the point made by my Lord Justice Bean, the point was that it was a contractual term because the issue was an enhanced payment or no, all or nothing. So either there was a contractual right to enhanced payment or there wasn't, and the Court of Appeal found that there was. So in my respectful submission that the Fosrock case reinforces the proposition that the language in the incorporated document is not the key consideration, but the key consideration is the aptness for incorporation, whether it's needed to fill a gap in the coverage of the main terms and whether it's sufficiently workable and relevant to a sufficiently important part of the wage work bargain to qualify as a contract term by inference. Just two more short passages from judgments, if I may, both first instance judgments. The first is the case of Hussein, which you will find at tab 5. The question in this case was whether certain provisions of a disciplinary procedure for doctors counted as part of terms incorporated into the contract. But what's relevant for present purposes is that at paragraph 168, where there are no page numbers, Mr. Justice Andrew Smith helpfully sets out a number of propositions, having looked at the authorities. One six eight, my lord. So there's no single test as to whether an employer and employee intended to agree that the provisions of an agreement, such as the disciplinary procedure, should be contractual between them, rather than advisory or hortatory, or an expression of aspiration, and if so, which provisions. The indicia that a provision is to be taken to have contractual status, which are, I think, of some relevance to this case, include, 1, the importance of the provision to the contractual working relationship between the employer and the employee, and its relationship to the contractual arrangements between them. My submission, that's pertinent for the present case, because, of course, passing the 75% test determines whether you go on to band 3 or not. At Roman 2, the level of detail prescribed by the provision, and again we respectfully submit that the detail about the 75% test is sufficiently clear to be workable, And that brings me on to Roman 5 over the page, or perhaps Romans 3 and 5. The certainty of what the provision requires. If a provision is vague or discursive, it's less apt to have contractual status. And at 6, whether the provision would be workable or would be if it was taken to have contractual status, because the parties are not to be taken to have intended to introduce into their contract of employment terms which, if enforced, would not be workable or make business sense. And the last authority I'll take you to is my namesake Kavanagh, tab 7, Kavanagh and Secretary of State for Work and Pensions. This was a case about whether the right to check off, as it's called, which is the right to trade union members to have their contributions deducted at source by their employer, had contractual force or not within the civil service. The court held that it did, and at paragraph 22, one can see, well, perhaps we should start at 18. The various editions of the defendant's standard written particulars of employment, which said this gives the particulars of the main terms and conditions of employment applicable to your appointment. It doesn't necessarily represent the whole of your terms and conditions. Your manager may also hold paper documents that show additional contractual terms and conditions which have been agreed with you. And then 2 paragraphs down, you're bound by any collective agreements in place as amended from time to time.
Sorry, where are you reading from?
Paragraph 18, my lord. It's simply the wording of the main contract itself. The document in which the alleged right existed was at paragraph 22, and it was the defendant's salary policy, which was on the defendant's intranet. And the second paragraph in is the reference to the right to choose to have check-off applied to your trade union membership. So the key point, and we'll see that this is recognised by the learned judge later on, is that the salary policy wasn't one of the documents expressly incorporated by reference. Paragraph 60 in the judgment.
Sorry, can you just tap over on despite its name? I've never looked at this case before. I'd just like to read the head name.
Yes.
My lady, I was going to move to paragraph 60, which is on page 842. Now, the question whether the check-off provision imposes a contractual obligation on the defendant depends ultimately on what the salary policy means in its context. To understand what it means involves discovering what inferences can be drawn from the available contractual and non-contractual materials about whether the parties jointly intended the salary policy to have contractual effect. In the context of this case, I'm not impressed by the defendant's argument that it's significant that the staff intranet is not referred to in the claimant's contractual documents as a potential source of contractual terms. First, the parties would not have foreseen when those documents were signed that there'd ever be such a thing as a staff intranet. Second, it's clear from Alexander and his saying that a document may have contractual effect even if it's not part of the materials to which the parties have expressly attached the label contractual. And third, the staff intranet is referred to in the current standard written particulars as such a source, and those documents do not refer to staff handbooks and the like as such a source. So the second reason is the relevant one for present purposes. It's a recognition that it's not necessary that one can trace an express incorporation by reference from the main contract documents itself. And that's my respectful submission, wholly consistent with Alexander, which has been appealed on numerous occasions, which has been approved, I should say, on numerous occasions in this court, and also from the Briscoe case, where again the court recognised that it wasn't necessarily expressly to incorporate by reference. And in Briscoe, I should have made this clearer, but there was no express incorporation by reference of the policy, which was held to be of contractual force. Paragraph 65, page 843, Her Ladyship, said that whether or not my theory about the transition from the code to the staff intranet is correct, I consider that applying the approach of Mr. Justice Hobhouse and Alexander and of Mr. Justice Andrew Smith and Hussain, there is nothing incongruous in finding that the staff intranet is a potential source of contractual terms. It's the obvious place for an employee to look for detailed terms and conditions if his written particulars expressly refer to it. But in addition, given that none of the documents referred to in the contractual documents is any longer available to be consulted, it's also the obvious place for them to look. They can't be expected to engage in extensive, if not impossible, archival research in order to find out what their detailed terms and conditions are. And by parity of reasoning, we respectfully submit that the obvious place to look to fill the gaps about the criteria for validity and compliance in relation to natural breaks is, or are, what I've called the national documents. And then finally, of relevance for present purposes, is paragraph 69 on the facing page. The factors identified by Mr. Justice Andrew Smith and Hussain also support the view that the check-off provisions are intended to be binding. They affect an aspect of the pay-work bargain, which is central to the contract of employment. They're certain in scope and sufficiently detailed. The associated check-off procedure is detailed and clear. The provisions are workable, found alongside other provisions which are plainly intended to be contractual in a place where the parties would expect to find contractual provisions. So drawing the strands together, and I hope refraining from merely repeating the submissions I made when going through the contractual documents this morning, we respectfully submit first that there is a gap to be filled from the main contract. That is recognised in the judgment at paragraph 27 at page 137, tab 11, I'm sorry. The first sentence in paragraph 27. It is common ground that neither the Derby contract nor the TCS themselves spell out how monitoring should be conducted, what is a valid monitoring round, or what criteria are to be met to establish non-compliance with controls on hours of duty or hours of actual work or rest applicable to a junior doctor's working pattern. So something has to be added to the main contract document in order to clarify when there will be validity, or more specifically, when there will be compliance with the natural break requirement. Our primary submission is that there's been express incorporation, as I've already submitted, through para 22A of the TCS, referring to the two health service circulars, and the reference in the second health service circular to the monitoring guidance. But third, even if we're wrong about that, in our respectful submission, applying the analysis in Alexander and STC, Briscoe and Lubrizol, and in the Kavanagh case, all the circumstances show by inference that the criteria for judging compliance and validity need to be incorporated, because it's a key aspect of the wage work bargain. It determines what the doctors get paid.
You say the criteria, the Department of Health criteria need to be incorporated.
Yes. The 75% thresholds, which we say is a 75% threshold for actual breaks, as recorded, as reported. And the fact that the incorporated terms are in health service circulars, and in one case a document headed guidance, doesn't detract from their contractual force. This is just for your note, I don't ask you to turn it up. In our skeleton argument, beginning at paragraph 28, at page 25, we deal with all of this. But we say that the cases show that the use of wording like policy, guidance, and so on doesn't disqualify something from being incorporated as a term in a contract. And in any event, though, we submit that the language used in these three documents in the main is the language of rules. And this is where I will, unless you wish me to take you back through them again, I won't repeat what I've said, save to refer you to page 25 and 26 of our skeleton argument, where we do identify the mandatory language that is used in each of these three documents when it's talking about the standards, the criteria that have to be met. Each duty period must be assessed individually. The data will need to be supplied, etc., etc. And finally, on this point, we respectfully submit that the reference to robust local monitoring arrangements, which is found in several places, including in the F1 contract itself, is not language that has the effect of granting a discretion to the trust to set the criteria. What it does is recognises that it's a matter for the trust to decide on the mechanism. My old man with a clipboard, or the computers opening a page in the computer and filling in an entry and that sort of thing. It's for the trust to decide how to do that. But in terms of the 75% thresholds and how they operate, that is a matter for the contractually binding force of the national agreements. My lords, my lady, just a signpost where I'm going next. I'm now going to take you to the local documents and make my submissions about why they are not incorporated. Then I will take you briefly to the relevant passages in the judge's judgment to show where we depart from them and where we respectfully submit that she erred. After that, all I need to do is deal as briefly as I can with the alternative irrationality argument. And very finally, there is a specific point in relation to the 22nd doctor on monitoring round 2, whose figures alone skewed the whole arrangement. And that's a freestanding but very short submission. So if I may move next then to the local documents and start with the Derby contract, which is in tab 1 of the supplementary bundle. Sorry, I should call it the F1 contract. I know the court is by now tediously familiar with it, but it's on page 3. and says that the trust is 6A, trust is contractually obliged to monitor junior doctors' New Deal compliance and the application of the banding system through robust local monitoring arrangements supported by national guidance. You are contractually obliged to cooperate with those monitoring arrangements. And Her Ladyship found that 2 local documents were incorporated into the contract of employment. Perhaps I can just show you before we look at those, and I'm sorry to dart from document to document or file to file. In the judgment itself at page 158, paragraph 112, perhaps I should start at 111. Having said that she doesn't accept our submissions, Mrs. Justice Simler says clause 6A provides in terms that monitoring is contractually required to be carried out in the manner provided for in relevant local arrangements. I can see no basis for restricting the meaning of these clear words as required by the claimant's argument. Further, the argument is inconsistent with the reference to local arrangements being supported by national guidance, since the relevant national guidance is plainly concerned not with the physical or logistical arrangements by which monitoring is conducted, but with the substantive methodology for monitoring and determining whether controls and hours are complied with. Put shortly, it's difficult to see why clause 6A should address physical or logistical arrangements, but not the substantive methodology to be used for monitoring. I'm pausing there, and I hope, without irritating the court by intervening, we say, in answer to the implied question in that last sentence, the reason is that the whole idea was that there were supposed to be national controls and consistent national controls over hours and over rest breaks. But then she goes on, what then are the robust local monitoring arrangements supported by national guidance? Seems to me in agreement with Mr. Leaper that the local monitoring arrangements referred to in clause 6A are those contained in the defendant's local documents, the Hours Monitoring Guide and the FAQ. These are the documents sent or readily available to junior doctors at the beginning of each monitoring round, and in context and in light of their content, they are the local monitoring arrangements referred to in clause 6A and incorporated by reference by it. The fact that they're not referred to by name is neither here nor there. The Hours Monitoring Guidance states in terms that its purpose is to explain both the individual doctor's and the employer's contractual obligations for monitoring compliance with the New Deal. In other words, the source of the contractual obligation to conduct monitoring by robust local monitoring arrangements is 6A, and the Hours Monitoring Guide and the FAQ explain or provide the detail of those local monitoring arrangements. The fact that the documents explain contractual obligations does not mean they're not contractual, nor do I accept that neither document purports to have contractual force in the sense that neither states that it has contractual force. That is not a necessary requirement. Now, pausing there, should there be any doubt that the conclusion that Her Ladyship is coming to is that the Hours Monitoring Guide and the FAQs are indeed contractual, she makes absolutely clear that that is her conclusion at paragraph 129 at page 163.
Do you say they're contractual, or
No. I'll say that they're not contractual.
so they can't even lie beside what you say are contractual terms?
No, the monitoring guidance, I'm quite happy for it to lie beside because it's wholly consistent. There is one sentence in the FAQs which we say misunderstood might be taken to be inconsistent with the national guidance. We'd say even properly understood, that's perfectly consistent with the national guidance. But if there is to be a clash, we would respectfully submit that it's the national guidance that takes precedence. And because if we're right that the national guidance is incorporated, there's no longer a gap that needs to be filled by the local guidance.
But if you're right that the national guidance is incorporated and takes precedence, then you say the local documents have no contractual force at all. They're just... like an announcement on the staff notice board, which may be wholly illegal or load of rubbish, really.
Well, what we say in reality is that they are helpfully and understandably trying to summarise what the national arrangements are for the doctors who work at the Derby Hospital. And just as in the Briscoe case, the staff handbook that tried to summarise what were the actual rules got it wrong, that staff handbook didn't override the incorporated terms so as to be substituted for them, rather it was just disregarded.
Can you show us the FAQ question or answer which you alluded to,
Yes,
which you're
of
not
course.
happy with?
What we have, and may I just, perhaps it's easiest to do it by referring to it and not taking you through it. In tab 5 is the monitoring guidance that Her Ladyship was referring to.
Yes.
And there's not anything anywhere in that guidance that is inconsistent with what we say are the national requirements.
Right.
Indeed, the introduction at page 51 says the purpose of this guidance is to explain your contractual responsibilities.
Yes.
And 2, second paragraph, new deal is contractual legislation. And then, whatever that is, but in paragraph 50, page 54, under number crunching and return rates, a 75% doctor and duty return rate is required for a monitoring exercise to be valid. And that's right. Doesn't take you any far, but you'll note perhaps at page 55 they have simply in the appendix cut and pasted what is Annex A of the 1998 HSC to set out what the requirements are.
Yes.
So, but I haven't answered my Lord's question directly. The question and answer begins in tab 6, page 57. In order to get to question 20, which is the one that the learned judge relied upon, it's just worth looking at some of the other questions. First one, I haven't received my username and password. 2, I can't log on to the system and I don't know why. That gives you a flavour for what the FAQs is about. But at 14 is an answer which we respectfully submit is both right and consistent with the national guidance. Question, is 100% return needed for each rota? Answer, a 75% doctor return rate is required for each rota monitored to be deemed as a viable return, and a 75% duty return rate is also usually required, i.e. actual hours worked recorded, not annual leave, study leave, etc., for the return to be deemed viable to analyse. Now pausing now, that's absolutely right, in my respectful submission. That's wholly inconsistent with the approach that the learned judge held that this documentation authorised. The last sentence seems, if my respectful submission has no relevance to the present case, because nobody was suggesting that a different duty return rate than 75% was appropriate in monitoring rounds 1 or 2. But the paragraph that the learned judge has focused upon is at page 61, question 20. What happens if there is a non-return? Answer, for each exercise there are 2 return targets which are set at 75%. The first is the doctor return rate. On an exercise of 10 doctors, you'd expect at least 8 doctors to return. That's wholly uncontroversial. The second is the duty return rate. Any missing duties are taken from the planned rota, so that the monitored average hours are a true reflection of the planned rota. At least 75% of the duties taken into account in the monitoring analysis have to be monitored, which allows up to a maximum of 25% of substituted data for annual leave, study leave, or any shifts not recorded. Now, our respectful submission, this isn't about natural breaks at all. It's about something else. It's about the substitution of hours. And I'm afraid I'm going to have to digress very briefly, if I may, to explain what the substitution of hours is about. And it's summarised, or there's a worked example in tab 8 on page 73 of the same file. You'll recall that wholly unrelated to natural breaks is the requirement that a certain number of maximum hours a week must be worked in order to qualify for band 1B. You have to work between 40 and 48 hours a week to qualify for band 1B. If you are higher than that, you go into a different band. So as well as evaluating the natural breaks issue, there is a wholly separate issue as to whether the number of hours on average that doctors are working in the monitoring round is consistent with the band into which the job has been placed, the rota has been placed. And as regards the assessment of hours, as compared to the assessment of natural breaks, it is necessary to do what is loosely described as substitution, because if you don't do that, on any view, the figures are distorted, and actually distorted in the doctor's favour. So, distorted against the doctor, but it's all accepted that you have to do something to recognise that if you ignore the fact that people aren't there and do an average, you'll end up with an average number of hours that is too low rather than the real average. I haven't expressed that very clearly. May I take you through the example to show you what we mean? And it's a simple, well, if any of these things are simple, it's a relatively simple example. So 10 doctors, each with a 48-hour contract. So it would be 1B, with a mix of 8-hour day shifts and 12-hour night shifts. So they have 10 night shifts altogether and 105 day shifts over the course of the fortnight. Now, if they're working exactly to contracted time and nobody takes any leave at all, so all of those shifts are actually worked, then if they're working exactly to contracted time, by definition, they will do an average of 48 hours per week.
Forgive me, Mr. Cavanagh, will you just stop for a moment and let me see if I understand it on paper?
May I seek to explain it in this way? The hours figure is taken by obtaining an average number of hours that each doctor does in the fortnight. You get that average by taking the total number of hours worked and dividing it by the number of doctors. If one or two doctors are absent for some shifts or all together, then the total number of hours actually worked is smaller. If you divide it by the same number of doctors, you'll come out with a figure that's artificially low because it doesn't actually reflect the number of hours each doctor worked on shift.
Yeah.
So what you've got to do is add back in some notional hours to bring it up to a total that is reflective of what is actually done. So what they do, if a doctor doesn't do a shift or a few shifts, you add in back into the total from which the average is drawn the number of hours for that shift. And that will capture, if doctors are all working exactly the right number of hours, it will reflect exactly what the true reality is. If doctors are working excessive hours, it will underplay slightly the excessive hours that they're working, because these notional shifts will just be the regular hours and not the regular hours plus a bit, but they will still reflect the fact that on average the doctors are working more than the average hours. And so substitution of hours in relation to the maximum number of hours in a working week operates so as to make more accurate, not less accurate, the true picture. That's completely the opposite when we look at natural breaks, because if you assume compliance with natural breaks when there's actually no basis for doing so, you are skewing the results in a way that doesn't make it more accurate. It's in a way that probably makes it less accurate. So if we come back to the FAQs, which this is in tab 6 in the supplementary bundle, we have always understood question 20 simply to reflect substitution of hours because of the second sentence in the key paragraph. Any missing duties are taken from the planned rota so that the monitored average hours are a true reflection of the planned rota.
Taken from, taken out of.
Yes.
Yes.
So, but it's a reflection of the average hours, not a reflection of the natural breaks.
Well, can it be put this way, that suppose the rota involves 22 doctors, of whom in the relevant fortnight 4 are on holiday. If you take the total number of shifts worked and you look at the returns for rest breaks by the 18 who were there, and you can divide by 18 to get an average figure, but you shouldn't assume that the 4 who are on holiday would have taken all their rest breaks. Exactly. You would say you should ignore them altogether.
Yes.
Yes. Right. I understand that.
So, ironically perhaps, in our respectful submission, there's nothing even in the FAQs that's inconsistent with the national guidance, but certainly it doesn't bear the weight placed on it in Her Ladyship's judgment that this is a bespoke contract term that allows them to add in non-existent duty periods when working out whether natural breaks have been achieved. But there is one further point in relation to the local documents, and that is that Her Ladyship overlooked a third local document which was in evidence before her and was common ground, was part of the documents that were issued or made available by the Trust, and that is tab 7. this is headed, you'll see it's dated the July 13, you can see just at the bottom of, very bottom of the page, but it's Derby's document, Medical Workforce Department, Policy on Monitoring of Junior Doctors' Hours of Work and Rest Requirements as outlined in HSC 1998-240 and as modified in circumstances that don't affect us. So there is a local document that is expressly making reference to what we say is the incorporated document. And more than that, the language of this is wholly consistent with what we say is the right approach to breaks, which is that it's only actual duty periods that should be taken into account. Just two passages. The bottom of page 63, or nearly page 63, penultimate paragraph. For a monitoring exercise to be valid, information relating to a minimum of 75% of each shift worked during the 2-week period must be recorded. And that's exactly what we say, because of the focus on each shift worked, which is not how the Allocate software does it. It's a minimum of 75% of each shift worked, plus notional for holiday, sickness, and so forth, expected, and so forth. And then on the right-hand side, exactly halfway down the page, it says, in order to have accurate information, it is necessary to obtain a 75% return rate of each shift worked, and for 75% of the doctors assigned to the exercise to have participated in the monitoring exercise. Now again, the reference to a 75% return rate of each shift worked is, we say, absolutely right, because it focuses on the shifts that are actually worked. Now there's no reference at all to this in Her Ladyship's judgment, though we did make this point before her, but we respectfully submit that this all serves to reinforce that far from creating a local discretionary methodology, this documentation, so far as natural breaks is concerned, is wholly consistent with the national documents which we say are the correct documents.
This is 2013 edition.
Yes. One sees that at the very bottom of, yes. You see at the bottom of each page.
You could say that this is the robust local monitoring arrangements which are supported by the other documents that you place primary reliance on.
Yes. May I take the court to the judgment?
Well, before you do that, can I just work out myself, if one looks at the document at tab 5 and the document at tab 7, both, I'm just trying to work out why there's a need for both. What's the distinction?
Yes, I think 5 is written in looser and friendlier language.
Right, so it really is the guide for junior doctors?
Yes.
Yes.
These are individuals straight out of medical school who are being required to do 1,000,001 things they've never done before. So, yes.
That's why there's a heart and everybody's smiling.
Though I may say so, I'm rather frightened by the person who's smiling in the very front of the photograph. But yes, my lord. And I do emphasise, so far as we can see, there is nothing at all different in what is said in tab 5 and what is said in tab 7. It's just written in a different manner.
Thank you.
May I take the court back to the judgment, and particularly to page 160? Paragraph 117, or perhaps I start with 116. True it is, as I'd submitted, that neither document states in terms, this is the two, the hours monitoring and the FAQs, that neither document states in terms that the defendant will not rely solely on actual duty periods worked in order to determine validity for monitoring purposes, or will treat each duty period actually worked but for which no return is made as compliant, or will count days of annual leave, etc., as compliant duty periods. So it's also true, as I'd also submitted, that neither document reserves to the defendant a general discretion to set the criteria for determining whether a monitoring round is valid or compliant. However, she doesn't consider that these points assist our case. Although the FAQ is not as clear as it could and should have been, and there is some internal inconsistency within it, I think that's a reference to para 14, I have concluded that this document does make sufficiently clear that the monitoring system used by the defendant substitutes data taken from the planned rota to make up for missing hours. See answer to question 20 in particular. It does not state that data will be substituted on the assumed basis that the duty was fully compliant with New Deal controls on hours and breaks, nor does this appear in the hours monitoring guide. In the case of both points, if I'm wrong about the FAQ and or in the absence of an express statement that substituted data will be treated as fully compliant, it seems to me that the result is simply that the local monitoring arrangements set out in the hours monitoring guide and FAQ do not prescribe a detailed methodology for monitoring to that level of detail. That doesn't mean that the adoption of a particular approach or methodology is necessarily impermissible. Rather, it means that the contract of employment does not make express provision at that level of detail about, for example, the way in which particular calculations will be performed or how prospective cover will be factored into the process. That's not unusual in a contract of employment. These often leave the detailed methodology to be adopted for a particular purpose. For example, the precise method of calculating annual bonuses to the discretionary judgment of the employer. It seems to me on this basis the detailed methodology to be used in the software setup or otherwise for calculating duty return rates and compliance where data is missing is left to the discretionary judgment of the defendant, subject to the duties of rationality and trust and confidence owed by the defendant to its employees. It was not necessary for the Derby contract to include an express provision reserving discretion to the defendant in order to achieve that result. And then she goes on to dismiss a separate argument on behalf of the defendant about custom and practice. So we respectfully say that none of these local documents have contractual force, and that the learned judge, I won't say overlooked because she was aware of the argument that we were advancing, but erred in law in failing to accept our respectful submission that there is a difference between the criteria that must be applied and the mechanics by which you set about doing the assessment. And we respectfully submit that it's clear from the national documents that there was supposed to be a consistent national criterion or criteria, but that the mechanics, the way you went about doing the assessing, my old clipboard example, were up to the trust. And that explains the reference to robust local arrangements. I should have shown the court paragraph 114, which I'll do now, because the learned judge says that the two documents, that's the two local documents, are not simply giving practical assistance to doctors participating in the monitoring process. Rather, in the language of conferring rights and obligations, they set out targeted rules. So she is regarding these documents, which we say simply summarise for local consumption the national rules, as if they are setting out targeted rules. So,
until you get to subparagraph little 8, which is FAQ 20, there's nothing you argue with.
absolutely not. The only reason we say, for what it's worth, that they're not themselves contractual is that they're already set out in the national contract rules. And all they're doing is summarising them.
And as to number 8, you say that insofar as it applies to number of shifts worked, there's nothing wrong with it. Either it doesn't apply to rest breaks, or if it does, it's a mistake.
So those are my submissions on the incorporation of terms, unless the court wishes to hear any more from me on that. Can I move on to Her Ladyship's alternative or additional conclusion that in any event we have misconstrued the national documents, even if they are incorporated? She deals with this at paragraph 126 of the judgment at page 162. Perhaps more importantly, and in any event, she has concluded that the monitoring guidance and other Department of Health documents do not have the meaning and effect contended for by the claimant. First, the Department of Health documents make clear that they're subject to the terms of the local monitoring arrangement. I've made that, I hope I've made my submissions on that already, that that's about mechanism, not criteria. Then she says that Annex B, Appendix 1 of HSC 98240 is not concerned with pay banding dealt with by paragraph 22 of the TCS, rather it's directed at working patterns in practice. That's clear from the consequences of failure to meet rest targets, which are that urgent consideration will need to be given to changing the working pattern or reviewing working practices within the existing working pattern to reduce work intensity to acceptable limits. In my respectful submission, that's wrong if one looks at HSC 98240, which is in the supplementary bundle at tab 2. Because the way this document is structured, one sees at page 20, at paragraph 2, is that the New Deal hours controls are set out in Annex A, and Annex A at page 24 says at note 3, information on how to calculate and monitor rest periods is contained in Annex B. And then Annex B sets out the 3/4 requirement, or the 75% requirement. But the point, therefore, is that Annex B was not purely about needing to make changes to working patterns in practice. It was also about the contractual controls, the contractual penalty for failing to comply with the rest breaks requirement, which is that you jump up to band 3. So Annex B is not purely about warning a trust that they have to get going and make life better in the future. And indeed, earlier in her judgment, Her Ladyship had recognised that the effect of a failure to comply with the requirements was that you had then to go ahead and pay people at the right amount, at the higher amount. That's at paragraph 23 of page, I'm sorry, no, that's at paragraph 132. I apologise, at page 164. So, in our respectful submission, that argument doesn't run. And then, in the next section of paragraph 126, Her Ladyship says that she doesn't read the paragraphs relied upon by us as indicating that only worked duty hours and shifts can or must be assessed. That's a reference to the DH monitoring guidance. And can I just show the court once again why we say it does in fact say that you must pay attention to the actual hours worked. It's in paragraphs 26 and 27, particularly paragraph 26 on page 47, tab 4, page 47. Particularly the last bit, reference to data needing to be supplemented by accurately recorded data, actual length of working week, rest achieved during the day and overnight, natural breaks, that can only be a reference to actual natural breaks, actual working time as opposed to rostered duty periods. Monitoring may throw up situations where the working reality is very different from the expected working patterns and could indicate the likely source of non-compliance. So that's the high spot for us in our respect for submission in contending that it is the actual duty periods, as one standing back from it would expect, that really matter.
In 27, there are some words highlighted in bold type. Is that in the original document?
Yes. My Lord, yes it is. And of course we would say that again, the reference to all duty periods worked over the monitoring period makes it absolutely clear what the focus is upon.
And you're drawing attention to the words actual length and working reality in the previous paragraph.
Yes, and the contrast with expected working patterns, which is not enough. And at paragraph 127 in the judgment, Her Ladyship says, as regards paragraph 27 that we've just been looking at with the bold type in it, that it expressly states that it provides a national framework under which a minimum return rate for monitoring data should be set at 75%. It was for employers to decide where to set their own return rate, provided it was at or above the minimum, pausing there, so no right to dilute the obligations. But this is the real point. This paragraph does not stipulate that the duty return rate is required to be calculated by reference to 75% of the duty periods recorded by junior doctors as actually worked during the monitoring period. Rather, it refers to all 75% of all duty periods worked over the monitoring period. Now, pausing there, in our respect for submission, that doesn't wash. The reference to 75% of all duty periods worked over the monitoring period can only be a reference to actual duty periods because of the word worked. If you're on holiday, if you're off sick, if it's a non-existent duty period, it can't be worked. And then she goes on to say that its focus is on ensuring a representative assessment, in other words, a valid and accurate assessment of hours worked and rest attained. Now, pausing there, the test for whether the assessment is representative or not is determined by the validity requirement. You need 75% of duties to have a return attached to them. If you do, then the framework treats the use of what returns that you have as being sufficiently representative to justify the conclusion that you come to. And then at para 128, Her Ladyship says, I don't agree that paragraph 17, which I haven't reminded you of, but that's the one that says each duty period must be assessed individually, that paragraph 17 and 26 mean that the result of the monitoring round must be calculated entirely using actual data with no substitution. This is not what either paragraph says. on its proper constitution, the DH monitoring guidance is silent as to whether or not the use of substituted data is permissible. Paragraph 26 expressly recognises that information or data on contracted duty periods, calculations for prospective cover within the team, and weekly shift rota timetables will be available. It states that this data will need to be supplemented by accurately recorded data. This does not mean that only actual recorded data relating to working times and natural breaks can or must be used. Well, with great respect, we simply submit that is wrong, and that what properly understood paragraph 76 is doing is, while saying you can start with your expectations, you've got to finish with what is actually recorded and what actually happened on the ground. And, sorry, there's one sentence I omitted to deal with. The last sentence of paragraph 127. Her Ladyship says that the expectation that systems will be determined, developed and operated locally is also apparent in the language of paragraphs 28 to 31. What paragraphs 28 to 31 are about is what I call the mechanics. It's page 47 of the other bundle. It's not about what the criteria are, it's about how you go about the nuts and bolts of doing the assessment. And just for the court's note, at paragraph 130, Her Ladyship summarises the true meaning and effect of the terms from the local documents, the House Monitoring Guide and the FAQs, which at 129 she's concluded were apt for incorporation and were expressly incorporated. And again, most of it is not controversial, except for Roman 8. These assessments could incorporate up to 25% of substituted data in respective periods of annual leave, study leave, or any shifts not recorded by submitted returns, the FAQ. But even there, we dispute it only to the extent that you can't use substituted data for natural breaks figures. My lords, my lady, those are my submissions on the meaning and effect of the national documents. My next section of my submissions, penultimate section, deals with the alternative argument, which is, if I've been wrong so far, we respectfully submit that the approach that is adopted by Derby Trust and Allocate fails the test of rationality. And I know, if I may respectfully say so, that the court is aware of the description of the way in which the arrangements work. So if I may, I'll confine myself, and do this as briefly as I can, to setting out what we say are the 10 reasons why the Trust's approach is irrational.
Only 10.
Sorry? Only 10. Well, I had 12 or 13, my lord, but I did have mercy on the court in relation to the other two. But they're all can be summarised very shortly, and I will summarise them very shortly. In case there's any doubt about it, may I remind the court that whereas all the arguments I've made so far in my submission are pure points of law, this is not quite such a pure point of law. This is the evaluation, a challenge to the evaluation of facts by the judge. Yeah. It's not the findings of primary fact, it's the assessment whether those facts as found lead to a conclusion that the approach was rational or not. Yeah. Last year, or perhaps the year, no, it was last year, in a case in which I was involved called IBM and Dalgleish, this court gave helpful guidance as to the approach of an appellate court when it is second-guessing, so to speak, the conclusion on the rationality test that was reached by a first-instance judge. And the On that occasion, I was arguing for something different from what I'm now submitting. On that occasion, I was arguing that the Court of Appeal can only intervene if the court below was plainly wrong. But that argument was rejected by the Court of Appeal, and the Court of Appeal concluded that this court has the power to intervene if it regards the conclusion that was reached on the rationality issue by the first instance judge as being wrong. So it's broader power to intervene than I had argued for in the IBM case. There's a very short passage in the judgment. May I just show the court that before I make my...
Well, I don't know whether anybody quarrels with that.
In that case, no.
We're not concerned with an appeal from, the second appeal from an employment tribunal. And the usual test on appeal to this court is that this court can interfere with the High Court decision if the decision was wrong. None of this, or pretty well none of this, depends on the evaluation of witnesses.
No, none of it does. Yes. Well, in that case, may I weary the court with my 10 points? As I've said, I will make them very shortly. And the first is simply this. And may I say that you'll find most of them, not all of them, recorded in our skeleton argument beginning at page 30. Our skeleton argument can be found in tab 3.
Yes.
And I hope I've got the page right. Yes, page 30. So the first one is at para 54. And it's simply this, that it's irrational to take into account duty periods that never actually happened, either for the purposes of validity or for the purposes of compliance. Because the whole idea must be to try and work out whether in the real world junior doctors in this hospital on this rota were taking their breaks or not. And if you count duty periods that don't actually happen, then there is a real risk of concealing a real problem to the disadvantage of the doctors and to the disadvantage of patients. Point 2 is that it is similarly irrational not only to count these non-existent duty periods, but to deem them all to be compliant. And I should show you how Her Ladyship dealt with this in her judgment, which is at paragraph 141, page 166. And I'll break it down if I may. The first sentence, where data for unworked shifts is missing from the monitored data in comparison with the contracted rota and is added back or substituted, an assumption must inevitably be made about that rostered shift. Well, pausing there, that's a reason not to do it in the first place, because you're adding in speculation when you should be assessing what's really happened. But then she goes on, since what is being assessed is compliance with the rota as a whole, and not merely those junior doctors who chose to submit monitoring returns, I consider it rational to assume that the substituted shifts that are added back reflect compliance with the contractual controls on hours and natural breaks inherent in the rota and pay band that applies to it. So far as worked but unmonitored shifts are concerned, since junior doctors are under a contractual duty to submit returns and know that they may benefit financially where shifts are non-compliant, it's reasonable to assume that junior doctors would file returns where shifts are non-compliant. It is therefore a reasonable assumption that if a junior doctor does not return monitoring data, this is because the shift was compliant. Now, in our respectful submission, that just doesn't work as a matter of logic, because if a junior doctor doesn't return at all, the great risk is that that will turn it into an invalid assessment. So it doesn't mean that they will get up to band 3, it means they'll stay at their old banding. So there is no perverse incentive, financially speaking, for junior doctors to simply refrain from giving a return at all. But secondly, that doesn't address the problem of duty periods which are deemed to be compliant, which never happened at all because of holiday or sickness or the expected cycle not reflecting the reality, because there's no basis whatsoever in our submission to assume that those were compliant. And actually the much more only logical approach would be to assume they would be compliant and non-compliant in the same proportion as the duty periods that were actually worked.
Doesn't this paragraph 141 deal with two different points? The last two sentences are the doctor on the rota turns up, does the shift, but doesn't put in a return. And the judge says it's a reasonable assumption that if, as it were, you don't complain, then you've nothing to complain about. That's one point. But the first 6.5 lines are dealing with other types of missing data where the doctor on the rota, for whatever reason, wasn't there.
Yes, I haven't put it as clearly as I should. And we say, as regards the first point, you can't assume that the only reason a doctor would not fill in a form was because he or she thought there was a perverse financial incentive to do so, because in fact there isn't one. But also, these are tired young people, and it's much, at least as obvious an inference that they're too tired and frazzled or exhausted to have filled in the form. But in any event, as regards what is dealt with in the first half of this paragraph, we respectfully submit there's no logic at all in assuming compliance when they never happened. That was my second of 10. My third of 10 is that the whole premise underlying the existence of a duty return rate, the validity precondition, is that a 75% return rate would be sufficiently comprehensive to be reliable. You therefore don't need to load the actual data that you have in order to have a sufficiently reliable result. The 75% doctor and duty return rate is what establishes the reliability of the result. And if trusts are allowed to add in non-existent duty periods, there's no point having a duty return rate at all. Point 4 is genuinely a very short point, and that is that the return rates as operated by the trust are to 2 decimal places. What is the point of having figures to 2 decimal places if in fact the starting point is not reflective of reality? Point 5 is that there is an illogicality because days off, 2 days off a week, are treated differently from days of holiday in the arrangements. The days off are quite rightly stripped out. How can that make sense then, or how can it make sense for days of annual leave to be treated as worked duty periods that are compliant? In both cases, the junior doctor's not at work. 6 is, I fear, it's really just another way of putting 1. In our respect for submission, there is no logic to assessing natural breaks by reference to expected duties rather than actual duties. It is just another way of putting number 1. But actually the reference to expected duties is a misnomer, because they weren't expected at all. Nobody ever expected that every single theoretical shift on the rota would be worked, because that would be to assume nobody ever took holiday. And I showed you there's a contract right to a holiday, and people fall sick.
Yes.
Point 7 is that at paragraph 142 of the judgment at 166, Her Ladyship says that our criticisms of the Trust's way of doing it are misconceived because our own approach is predicated on deploying assumptions and making extrapolations. Any approach has limitations or potential drawbacks. What that's a reference to, as we understand it, is that our approach recognises that the assessment will be made on the basis of perhaps no more than 75% returns. But that's simply what the rules say. The difference is that our approach applies the rules, as we say they are, whereas the respondent's proposed approach relies on homemade assumptions that everything that's not recorded is compliant. And that also, in our submission, shows that Her Ladyship was wrong at paragraph 144 to say that whilst the choice adopted by the Trust may tend to skew the assessment towards compliance, that is the natural converse of the claimant in the BMA's proposed approach, which would skew the assessment towards non-compliance. With great respect, it does nothing of the sort, because our approach simply does the assessment based on the true data as regards whether doctors who were actually there got their natural breaks or not.
Do you accept that if averaging is impermissible, then that might produce an unrepresentative result?
Averaging in relation to which?
To say that the 2-week period for the monitoring may not be typical.
Yes.
So a fairer result might be achieved by testing it against, say, the average figure for the last 12 weeks.
Yes, certainly in theory. There's obviously been a collective agreement at national level that this would be measured by way of monitoring rounds. And yes, it's of course possible that a monitoring round might be unrepresentative. That's in the nature of the beast. But it is a very different thing from the Trust's approach, which guarantees that the results of the monitoring round will not truly reflect what happened during the monitoring round period. Malena Junior has just passed up a note saying that the guidance requires the Trust to use a representative period. Of course, it's not in anybody's interest to use an unrepresentative period. But anything other than assessing every single duty period on every single day of the 22-week period runs the risk of being unrepresentative. But it was agreed at the very outset on a national level that there would be a monitoring, a snapshot, as I've put it, a snapshot monitoring approach. Number 8, Her Ladyship said that it was inconsistent for the BMA to be content with substitution of hours and not to be content with substitution in relation to natural breaks. But as I've sought to submit earlier this afternoon, they are chalk and cheese, they're completely different things. This case is not about substitution of hours. There is a logic behind substitution of hours because it does produce a closer to an accurate result, which a substitution of natural breaks simply does not do. In fact, it's a shame really that the word substitution is used in relation to both processes because they're two completely different animals. Nearly finished. 9, para 145 of the judgment. Her Ladyship refers to the fact that the evidence shows that the defendant's methodology was widely used across the NHS. Well, that, with respect, is entirely neutral. Either it's a breach of contract, as we say, or it's not. It can't possibly assist the claimant's case or the defendant's case that it's used broadly. May I just interpose here, and I'm not going to take you to it, but in the authorities bundle at tab 9, there is an employment tribunal case called Chamberlain, which was dealing with this very same issue. And my learned junior Ms. Keogh acted for the BMA in that case also. And there is, although the court is no doubt fed up with hearing summaries of the way in which the allocator arrangements work, there is a helpful summary of it in paragraphs 24 to 35 of the Employment Tribunal's judgment. And of course it's not binding on the High Court, let alone on this court, but for what it's worth, the Employment Tribunal in Chamberlain accepted the BMA's argument that there was a breach of contract resulting from the use of exactly the same type of approach to natural breaks in that case as in this case. And finally, number 10, in our respectful submission, given that what we are supposed to be dealing with here is an objective and consistent way for assessing whether natural breaks are being obtained to the necessary minimum amount, it makes no sense at all in our respectful submission to grant a broad discretion to one of the parties to the contract to have its own arrangements which are self-serving, if we may respectfully say so. It's no criticism of Derby specifically because this is the Allocate software, but it is an arrangement that can only work one way. My final submission is a standalone final ground. It's ground 7 of our grounds of appeal, but it is, in our respectful submission, symptomatic of the difficulties that arise from the trust and allocates approach. And it's paragraph 151 of the judgment. I'll deal with this quickly because I've already flagged it up to the court. Paragraph 151 of the judgment, which is page 167. There was a straightforward administrative error in relation to monitoring round 2 in that they calculated validity on the basis that there were 22 doctors on the rotation when in fact there was only 21. And had they calculated it based on a 21 doctor shift, then it would have been valid even on their own figures, leaving everything else aside. So the only reason that the monitoring round 2 was held to be invalid was because of this mistake in relation to Dr. Mohammed. And the learned judge deals with this at 152 and 153. She said, "I do not consider that this means that the defendant acted irrationally in breach of contract. For the reasons given above, the defendant was entitled to adopt a denominator of 218, that's 22 doctors, being the shifts expected to be worked by reference to the contracted rota as a whole, which was being tested during this particular monitoring period. Since the purpose of the monitoring exercise was to assess compliance across all expected shifts for that rota, the defendant was entitled to conclude that the exercise would be valid only where actual returns were submitted in respect of 75% of the shifts expected in the relevant period. In our respectful submission, this entirely highlights the illogicality and the inappropriateness of the approach that was adopted by the Trust, because it was never possible for 1/22nd of the shifts to be the subject of returns because they were never done. The doctor wasn't there. So in our respectful submission, it makes no sense to assess the 75% as against 100%, which included one extra imaginary doctor. But at paragraph 153 she goes on, alternatively, if the defendant was required to exclude Dr. Mohammed altogether, the logical consequence is that this monitoring exercise was rendered invalid by reason of the flawed basis on which it was conducted. Or, as Ms Atkins expressed it, it was a cancelled or void exercise. I do not consider that the only option open to the defendant was to treat MR2 as valid in the circumstances by performing an alternative calculation that excluded Dr. Mohammed after the event. Rather, the defendant was or would have been entitled to conclude that MR2 was invalid and that remonitoring was called for. Well, in our respectful submission, that just can't be right, because there wasn't anything invalid about monitoring round 2. There was the right number of doctors, the right number of duty periods had been submitted by way of return in order to meet the 75% validity requirement. All that had happened was that there was an administrative error in the medical staffing department that had got the sums wrong. So in our respectful submission, the only possible consequence for that is that it should be declared a valid round, not an invalid monitoring round. And we, as I've already said, if that's right, then even if everything else I've said is wrong, it would still mean that from that point onwards and from 3 months prior to it, or 3 months after the last monitoring round, the doctors concerned were entitled to a band 3, not band 1B.
This is a freestanding, as it were, 5-minute point that Dr. Hallett and her 21 or 20 colleagues win this case, even if they lose on every other point, simply on the calculation being wrong.
That is right. Although we also say
it doesn't make it much of a test case, but
but it is significant because it's a symptom of wider malaise. We respectfully submit.
Yeah.
My lords, my lady, may I just turn my back for a moment? Just one final point. My Lord Justice Bean raised the possibility of unrepresentative monitoring rounds, just for the court's note. At paragraph 20 of the National Monitoring Guidance, it's stated that non-typical periods should be avoided, and at paragraph 27, it's made clear that this should be deemed to be a representative period. So it's embedded in the process. We would respect.
Sorry, paragraph 27 of.
Or again, of the monitoring guidance, of the National Monitoring Guidance. Finally, my lords, my lady, the relief sought in these proceedings is declaratory only. If the court were in our favour, then I would suggest, as we did below, that the parties would put their heads together and draft an appropriate order. Unless there's anything I can assist.
Yeah, just one short point in relation to the last ground. Paragraph 152, the judge says, refers to the defendant acting irrationally in breach of contract. Where does she deal with the obligation to act rationally in contract?
Yes, sorry, forgive me. There are. It's a para 118. 3 lines from the bottom. She notes that the decisions are for the discretionary judgment of the defendant subject to the duties of rationality and trust and confidence owed by the defendant to its employees. But there is an earlier passage, I think, where there's a reference to rationality. May I just check that? Oh, thank you. 134. I'm very grateful to my excellent junior. Yes, it's 134. Thank you very much.
Thank you.
Thank you very much, Mr. Kavanagh. Yes, Mr. Kavanagh.
I propose dealing with my submissions as follows. I would wish to start with two general points concerning, firstly, the Trust's approach to ensuring natural breaks, and then secondly, the purpose of monitoring. Dealing with those two general points before addressing grounds 1 to 4, which are the relevant applicable terms and their meaning, and that obviously in line with my learned friend is going to be the largest part of my submissions. Then dealing with ground 5, which is rationality, and ground 7, which is the specific issue on monitoring round 2. Ground 6 is simply an expression of a conclusion, as I understand it, from grounds 1 to 4 and 5. So firstly, the general point about the Trust's approach to ensuring natural breaks. And I raise this directly in response to what my learned friend just said, which was a reference to a wider malaise. There is no finding by the trial judge that there was any such malaise. Quite the contrary. This is a trust which was not seeking to shirk its obligations in any way. And I'd like, if I may, to take you to a few specific references in the judgment. First of all, paragraph 39, which is in the Core Bundle tab 11, page 144. And in the last 4 or 5 lines of that, the judge below refers to evidence that had been given and says, in relation to it, it seems to me to reflect the actions of a responsible medical staffing department taking appropriate steps to ensure that natural breaks are being taken on an ongoing basis, and where they were not being taken, helping junior doctors to report that fact so that it could be addressed for the benefit both of junior doctors and patients. And moving into paragraph 40, the judge also concluded that there was an appropriate management determination to support junior doctors by securing a change of culture in respect of natural breaks, including by gaining the support of individual consultants on this issue. And this was a finding based on a range of evidence that the trial judge had heard. She refers, for example, in paragraph 38, in the last few lines, in the second line onwards, there was an induction programme on the 8th of August 2013, which emphasised the importance for junior doctors of taking natural breaks, as the claimant accepts. So right from the start of the claimant's employment with the Trust, at the point of induction, the Trust is emphasising to her, as a new junior doctor, the importance of natural breaks. And moving into paragraph 41, the judge describes here that there was a consistent approach on the part of the Trust to ensure that medical staffing were aware of practical difficulties preventing junior doctors from taking their natural breaks. And she said the head of medical staffing and others repeatedly invited junior doctors to raise difficulties and to say as quickly as possible if they were unable to take natural breaks so that help could be provided. And a specific instance was given of Dr. Potts, who gave evidence on behalf of Dr. Hallett. When she raised an issue and asked for help, it was provided. In relation to monitoring round 2, so that is the round that did apply to Dr. Hallett. She participated in it, as did Dr. Potts. That was a round in which Dr. Hallett completed records for all of the shifts that she worked, and all of her shifts were compliant with natural breaks. If I could ask you to look at paragraph 62 on page 148. This is reference to the evidence that was given by Dr. Potts, the only other doctor who gave evidence at the trial. She had said in her witness evidence that she rarely had an opportunity to take natural breaks, but the judge found that this was inconsistent with contemporaneous events. In a very average 2 weeks, she accepted that it was a very average 2 weeks. She had 4 days off. She was able to take her natural breaks in 7 out of the 10 shifts in which she submitted returns. And if you look at the last, I think it's 7 lines, the line begins significantly. Significantly, she was able to complete the diary card for monitoring purposes on a daily basis, making detailed and comprehensive observations on the shift worked that day. No doctor gave evidence to the court that he or she had had difficulty in completing the records because they were so tired at the end of their shift. That was not the evidence. But it's a speculation that continues to be advanced by Dr. Hallett to this court, both in the skeleton argument at paragraph 55 and in my learned friend's submissions, and that is in the face of the judge's findings. Moreover, the records did not need to be completed at the end of the shift, although Dr. Potts in fact did that, but they could be completed up until 2 days after the monitoring exercise period closed. That is set out at paragraph 58 of the judgment. And that finding that the window closed 2 days after the monitoring period is something that one can find in the local monitoring guide, which I'll obviously come on to in due course. It's an example of a local arrangement, the period during which the records can be submitted. Nowhere else is the period for submitting monitoring records set out. So that is the Trust's approach to monitoring natural breaks, and the encouragement of junior doctors to take them, and the encouragement of consultants to make sure that they are taken. The second general point is the purpose of monitoring. Put simply, the purpose of monitoring is to assess the rota as a whole, not just the fortnight that is being monitored. This comes again from the judgment. It is not assertion. And so if I could ask you to look at paragraph 67 on page 149. In the last 5 lines, there's a sentence that begins, furthermore, although a 2-week period is actually monitored, the monitoring is directed at assessing the rota as a whole to see if it is fairly seen as compliant with its particular banding. And what the judge is doing here is recording evidence that had been given by Mr. Digweed. One sees that at the beginning of the paragraph. And he, as my learned friend has said, was the product manager employed by Allocate. And the judge accepted that evidence. Moreover, if you look at paragraph 69, again, as Mr. Digweed explained, the purpose of monitoring the entire group of doctors on the particular rota and assessing pay for the entire group is to try to capture an assessment of the whole rota rather than just the fortnight monitored. And further, the claimant accepted this objective. So Dr. Hallett, in her evidence, accepted that this was the purpose of the monitoring exercise. The judge returned to the point at page 165. And at paragraph 138 at the bottom of the page, the purpose of monitoring any given 2-week period is to assess compliance with controls on hours and natural breaks, to ensure that the contracted pay band for the junior doctors on a particular rota is appropriate for that rota as a whole. Here, the general surgery F1 rota. The system.
Sorry, Mr. Leaper, you said paragraph 69 and then at where?
Paragraph 138 is the next reference, page 165.
Yes.
And the paragraph's at the bottom of the page. Perhaps you could just read paragraph 138.
Yes. Yes.
And the last sentence of the paragraph emphasises this point, that the system that's adopted by the defendant must be capable of producing monitoring results for 80 rotas in each monitoring exercise. So there isn't just a monitoring, obviously, of the general surgery F1 rota, but every rota that the doctors in training are undertaking across the trust have to be monitored, and that in this case was 80 separate monitoring exercises for 80 separate rotas, so that on each rotation there could be an assessment that the rota as a whole was compliant, so that it had been established in a manner which was consistent with the banding that had been attributed to it.
And it's the same fortnight used for all 8.
That's my understanding. Now, there's a reference there to the particular rota as a whole. And that rota is constructed on a particular basis, which is, as I understand it, unusual to doctors or doctors in training. It's one that doesn't reflect the reality of what's going to be taking place, that there are going to be a certain number of staff needed to undertake, say, cleaning duties in a particular area on particular days. Because it's a rota that is constructed to take into account prospective cover. And that was explained by the judge at page 149, paragraph 68, again referring to Mr. Digweed's evidence but accepting it. You see in the second line, furthermore, as is common ground, the rota is constructed on the basis of prospective cover. That means that when it is established, the rota factors into the calculation of the number and length of shifts or duties required the fact that doctors will be taking annual leave in the course of the rota because they have an entitlement to it, as my learned friend has pointed out. The rota does not allow gaps for annual leave days, but instead calculates the number of hours overall required to enable individuals to take days of annual leave within that period, and those hours are reflected in the contracted rota template once it is constructed. So the rota is, unlike rotas in most areas, it has a theoretical construct to it. It works out that within the period of the rotation, which is roughly 4 months, there is going to be an entitlement to annual leave for each of the doctors that works within it. But no one knows which days they're going to be taking. No one actually knows how many days they might take in that particular 4-month period because they have an annual leave entitlement. So the rota is constructed to have a number of shifts within it which reflects the fact that there is an expectation that a number of days, a projection, that a number of days are going to be taken as annual leave within that period, but it's not entirely sure when exactly it will be, how many might be off on a particular week, and so forth. And there's a difference there between the normal rotated 2 days off, because they are set into the rota. They are predictable, they can be factored in. But the annual leave days cannot be, because there is a construct in the way it's done. And that is described by the judge at paragraph 68.
It is, Mr. Leakin. I must say I don't understand.
It is extremely difficult as a concept, because it is predicting what, as best can be done, can be anticipated. So there are a larger number of duties put in place with an expectation that some of those are not going to be filled on any particular day because the doctor takes that day as annual leave. Doctors who are working are able to take up the slack in those periods because it has been projected in. They might have a slightly more intensive period of work when a colleague is off, but they know that their time is going to come when they get to take annual leave, and so they get the annual rest at that point, and someone else who is working will have to take up the slack at that point. So it is not an easy concept to work out how any particular week or 2 week period is going to operate, but the rota is constructed to take into account annual leave, and that is why it's described as including prospective cover, and that is why it's important, for reasons which I'll come to, but that's why it's important that the judge found that the purpose of the monitoring exercise is to assess the rota as a whole, and that is a purpose that the claimant herself acknowledged as a purpose of the monitoring exercise. So the assertion that's being made, and has been made again, to this court, that really all it's about is looking at the actual working day and whether or not within what one would understand to be a normal rota at a coffee shop or for cleaners or such like, where there's a level of predictability within it. It isn't that straightforward, because the assessment is to see whether the rota has been constructed in a way which means that it should be compliant with the banding that has been set, which is here, level 1B.
Yes, but that seems to me to beg the question. I still don't understand paragraph 68. A rota consists of 22 doctors, is that right?
Yes.
And Dr. Hallett, right. So it's a reasonable assumption that in a typical fortnight, 2 of those 22 might be away.
Yes.
But you say the rota is constructed on the pretense that nobody ever takes any holiday, and then at the last moment substitutions are made because, in fact, doctors, let's call them U and V out of A to V, are away.
It's not quite like that, because if all of the doctors were working, which is entirely possible, effectively the shift or the shift would be overmanned, overpeopled, because the number of shifts which have been put in are in excess of what is necessary. But they're allowing that there might be someone who is taken away. So there are going to be periods of effectively overstaffing, not by a great deal, but of overstaffing, because there are going to be other occasions when a member of staff is going to be away, and the doctors who are working will have to pick that up. So it isn't an anticipation, there's no substitution. It isn't, there would be if you were thinking about someone being on annual leave within an ordinary rota. you as the employer know that you've got to get someone in to cover that shift because there won't be someone working. There is no substitution here. That expected period is simply not worked. The doctor who is on annual leave doesn't fill that shift, and it is an unworked expected shift. And the rest of the people who are on that shift are effectively covering, but that is built into how the rota operates. And this is not peculiar to this trust. This is how the shifts are calculated. And I'll come on to show how this feeds into, in particular, the national documents. It is something which is anticipated, and one sees reference to it. It is a difficult factual concept, but that is what is being assessed in these monitoring processes. I'm very happy perhaps to come back to it, but it may be that a way to do that is once we've looked at some of the documents to understand a little more about how they describe this feeding in. The reason I flag this is that it is a contrast to the perhaps attractively but beguiling simplicity of the approach that is suggested by Dr. Hallett. And so, for example, she has said, and this is paragraph 59 of My Learned Friend's skeleton, it was no function of the monitoring process to provide a comparison with the expected duties across the rota as a whole. But that's not right, because the judge has found that the purpose of the monitoring exercise was to look at the rota as a whole. It does look at expected duties. It's to see if the rota as a whole works by reference to a 2-week monitoring window. And as has been submitted this morning, My Learned Friend's skeleton at paragraph 54 say this: the whole purpose of the monitoring exercise is to obtain an accurate, reliable indication as to whether in the real world junior doctors are able to take their natural breaks. This is with a view to trust doing something about it if the doctors are so busy they cannot do so. But this is something which is asserted but is not consistent with the purpose of the monitoring process identified, found by the judge below, and also accepted by the claimant in her evidence. One other point that has been made and was made to you not very long ago is that it is a far more likely explanation that is for a non-return is that the junior doctor is just too exhausted to make a return.
Well, let's not go on to that. Can we come back to that sentence you focused on in Mr. Kavanagh's skeleton argument, paragraph 54, line 5. The whole idea of the monitoring process is to obtain an accurate, reliable indication as to whether in the real world junior doctors are able to take their natural breaks. True or false?
Well, I've lost the passage myself. Let me just turn it up if I may. The idea of the monitoring process is to ensure that the rota as it is constructed produces a compliant result. And that is tested by looking at a 2-week window to see what is actually happening, because you look at the returns that you get from people who make the returns and then you assess them.
Compliant with what?
I'm sorry?
Compliant with what?
Compliant with the requirement that there be natural breaks. And so individuals who submit a return are essentially ticking a box which says, on this occasion I did get my natural break, or I didn't get my natural break. And as you see, Dr. Potts was able to make detailed notes as to the circumstances in which she did or she didn't. And so what you're required to take, and there's no dispute between us, that there is a requirement that there be a 75% level of compliance in the returns that there are. But the question is, what are you assessing it against? And the purpose of this exercise is to look at the rota as a whole, and that means, for reasons I'll come on to develop, but that means that because you're looking at a theoretical construct, it is necessary to feed into the fact that there are duties that were expected to be worked but that aren't worked because individuals, for example, are on annual leave.
I'm sorry, I still don't understand it. Do you agree or not agree that the whole idea of the monitoring process is to obtain an accurate, reliable indication as to whether in the real world junior doctors are able to take their natural break?
I don't disagree with it, save that it doesn't recognise that the assessment is within the context of the rota that operates as a whole over a 4-month period. And so it is not simply enough to say we have to look at the specific individuals who happen to be working in this particular 2-week period in circumstances where we don't know whether there are going to be a certain number of doctors on annual leave, whether there's some that are off sick, because we're not just looking at what happens to these doctors on these days. We're trying to ensure that the rota as a whole has been designed in a way that will ensure compliance over the period of the rota. And that period of the rota does factor in that there are going to be periods or aspects of push and pull. But over the way in which the rota is constructed over a 4-month period, it should be one which ensures that the individuals will get natural breaks. And recall as well that we're talking about 75%. And that factors in that there is a 25% tolerance within this. So this is not looking, say, at an individual cleaner operating a rota. Does he get his natural breaks? Because you can, as this sentence suggests, in the real world, you're looking to see whether he has actually got his breaks. But that isn't the exercise that is being undertaken, whether the particular doctors working the particular shifts in that particular 2-week period have actually got 100% of their natural breaks as they are ordinarily entitled to receive. Because you're looking at a theoretical construct, and it allows an assessment where you have 75% achievement. It builds into the assessment process.
That's a different point. I don't understand on what basis the trust is allowed to pretend that doctors on holiday were at work and taking all their breaks.
Because the reason is that the rota has been constructed in a way which factors in that there may be people on annual leave, that they may not be taking it at any particular one point. So the rota construct, which is what is being tested, builds in, is constructed in a manner which will allow the doctors who are working to take natural breaks, all things being considered. And that is what is being tested. So the fact that you have a number of doctors on annual leave is something that should be taken into account when you look at the fact that there are doctors who are actually working who have not been able to take their natural breaks. It's part of the overall assessment. And that is...
It's a program.
To an extent it is, but it is a combination.
You could contrast it with Mr. Kavanagh's man with or woman with a clipboard saying, well, have you done shift and have you had your natural breaks? That's another way of doing it, but this is simply a computer program.
It clearly is a computer program. That's how it was designed.
Yeah.
But it's a program which is looking at how the rota as a whole has been constructed. That is what the claimant accepted was the purpose of the monitoring exercise. It is to look at the construction of the rota. So it's not as though you've got someone with a clipboard who is standing at the end of a day and who is simply saying, did you get your natural break, yes or no? Because if people aren't getting their natural breaks I was going to say the real world, but in this non-specific, differently constructed world, if you're looking at a normal rota and employees are not getting their natural breaks. They'll say, well, I was on shift, I didn't get my natural break. That is a breach. And that would be, that's what this sentence, which we've been focusing on, that's what that sentence suggests the analysis is limited to. You're working today, did you get your natural break, yes or no? And the exercise is not constrained in that way. It is looking at the whole generation of the rota that has been put together. So yes, I don't disagree for a moment that this is to an extent an exercise which is set out, it's mathematical, it has an underpinning in software. I don't disagree with that. But that's because the rotas to operate within hospitals have to be constructed in a way which allows for there to be periods where you may be overstaffed, to take into account that there are going to be other periods where people are on annual leave and there is a slight shortage. And that is why, in my submission, you don't have 100% compliance rate. You don't say, did these doctors who were working get their natural breaks, yes or no? Because if they didn't, there is a breach. That is not how this is constructed in either the local or the national documents. It is a process which is seeking to ensure that there is a certain level of compliance and allows for a tolerance, and quite a significant tolerance, of non-compliance. That is all a feature of this being part of an assessment of, within a short window, of an overall rota across a 4-month period.
I confess I grapple. I understand what you're saying about taking the rota as a whole. What I really grapple with is the assumption that given the unpredictability and the level of speculation within the working basis, the assumption can be made that the returns which haven't actually been returned will be compliant. I just don't understand how that assumption can be made.
As I think my Lord Justice Bean pointed out, when the judge deals with it, there are two particular circumstances. One is where the shift has actually been worked but no return has been put forward. Is that, may I ask, is that
it's
right?
Yeah.
So, and the alternative is that the shift has not been completed because the individual is on annual leave. So there are two slightly different circumstances. Where it's someone who has worked the shift and not completed the return, then the assumption is, well, had there been a problem, they would have submitted a return as they are required to do. We know that they worked. They haven't told us whether they got a natural break or not, and therefore we have to do something. We're going to assume that they were compliant. They did have a contractual obligation to submit these returns. The alternative circumstance is that the individual doesn't work the expected shift because they're on annual leave. And again, what is done by the software is to put forward that has been a compliant shift.
Yes, but why? How can that be fair?
Well, because there are other because within the rota as a whole, these things will even out. There'll certainly be circumstances where there is the overstaffing that is anticipated within the system. And so across the period of the rota as a whole, there is overall going to be compliancy, even if there isn't for a particular doctor in a particular shift because they're dealing with a colleague being on annual leave. And so there has to be a taking into account, which is why there is this, when you look at a 2-week specific window, you're taking account of trying to take account of how the rota should be operating over a much longer period. And this is the approach that the judge, with respect much more eloquently, has set out in her judgment as to why, because you're not looking, as you ordinarily would for a member of staff, at what they're doing on a particular day and whether they've got their natural break, that is normally the end of the inquiry. You know whether your rota whether your working practices mean that people aren't getting a natural break because they haven't been able to take it. They've just been too busy. But here, because you're assessing how the rota has been constructed, one aspect of that is taking into account that people may or may not be on annual leave. There may be a compression of people on annual leave in a particular 2-week monitoring period. If too many people are on annual leave, if that should happen, you're not going to get your doctor return rate. So there's an amount of elasticity within the 75% figures which take into account that these variables, because you're not looking at a set rota for a particular week, but you're trying to assess a much wider period.
It's perfectly fair, I would have thought, to disregard people who are off sick or on annual leave for the purpose of deciding whether you've got a 75% rate of return. But I don't understand why it's fair to, rather than simply cutting them out altogether, to pretend that they were there and taking their breaks.
Because if you look at a particular week where, say, there are 2 members of staff who are on annual leave all of that week, that means that you are likely, I assume, to get non-compliance over your monitoring period for natural breaks. Because in that 2-week period, the staff who are remaining will have had to work hard and will not get their natural breaks. But the consequence of this would be that all of the doctors for the entirety of the 4-month period would have a determination that the rota for the 4-month period is non-compliant. There is then a penal sanction applied to the trust, which is that they have to pay all of those doctors for all of the 4-month period and until there is a remonitoring and with a retrospective effect at a very much higher level of pay, the Band C payment. So the consequences are very substantial, and it would be as a result of the fact that in that particular 2-week period, for reasons relating to people taking annual leave, or perhaps one being on annual leave and one being off sick, unpredictable factors, that period would become representative for the entire rota for all of the people working on it. But that's where the fairness comes in. That is why there is a factoring in of compliancy for people who are on annual leave or are sick. In contrast, and I fully accept this, to the predictable days off, which individuals will get within the ordinary rota, and that's factored in, but you don't need to give any credit or any offset for those, because that's how you know that's happened, you know why it's happened, and that is predictable. But for the period where you've got a couple of people off causing a particular tension within a particular rota for that 1 week or 2-week period, if you don't take account of the fact that you've got effectively compliancy for the expected days of work, you are misrepresenting what actually is happening with the rota as a whole. It does, I accept, it must, to a degree, misrepresent what happened in that 2-week period, because you're being told that there were a higher level of failure to secure natural breaks than was appropriate, because individuals are not getting their natural breaks. But provided you've got the 75% compliancy, having factored in that people are on annual leave, then the rota as a whole is soundly arranged to allow for natural breaks overall. I mean, that is the only way. It's a consequence of the pay grading structure. It is right that there is an importance on ensuring that on any particular day an individual working gets their natural break. That is, of course, is right. But the way that if there is non-compliancy for a particular 2-week monitoring period, the consequences are that for the entire, at least 4-month rotation, even though on every other week the doctors have had full natural breaks, they will get their penal, or generous, but penal to the trust, level of pay.
It's not penal.
It's penal to the trust. It's designed to be penal to the trust. That is the purpose of it. It is a particularly high rate of pay which is put in place at Band C, or was, to discourage, to ensure that trusts get their working arrangements to be compliant. So it is, and it provides to the doctors a substantially enhanced level of pay. So that means that there's this is not just about saying you didn't get your natural break this day on this shift and I need to sort out that particular arrangement. Because what the trust does in that case, and the evidence was, is that Dr. Potts says, I've got a problem today, goes to the staffing office and they sort it out so that the corrections can be made. But this is looking at where there is whether or not the monitoring period can properly be said to inform whether the rota as it has been constructed to operate over a 4-month period at a level of banding 1B is properly constructed. So it's trying to strike out the unfortunate 2-week window where something has happened which means that there's a particular squeeze on natural breaks in that period. And that's why I started with the purpose of the monitoring exercise. It is to ensure...
Mr. Lee, two different points. One is the averaging point, which I put to Mr. Kavanagh. His response, and you'll no doubt deal with it, is, well, it's too bad, that's what was agreed. If the fortnight selected turns out to be unrepresentative for a particular rota, well, tough. But one could debate that. But what you're saying about leave builds in a skewing of the system, whether one averages or not. Of course, given given that even hard-working doctors are entitled to a certain number of days leave a year, in any given 2-week period, there's highly likely to be 1 or 2 people off, and if you averaged over 4 months, it's even more likely there'll probably be 7 out of 22 people off.
Absolutely.
But why does that? I still don't follow why it entitles you to skew the figures so that the 75% is not 75% of hours actually worked, but it's 75% of the total workforce on the assumption that the people on holiday are actually there at work and taking their breaks.
Can I answer it this way? If you have a regular rota and you know someone's going on annual leave and you've got the same work to be done, so you think about the coffee shop and you've got 3 people who are working, one of them's going to go on annual leave. You don't just leave the other 2 to sit and work because you've got the same shifts that need to be filled, so you have to get a temp in. And you have to get cover for those shifts to make sure that everyone can operate in the ordinary way according to their ordinary shifts. Within the hospital environment, that isn't something that takes place. You can't get someone across from somewhere else to fill a gap. The way that the rota is constructed, universally, is a way that anticipates that there will be some level of absence. When exactly it is can't be predicted. People are allowed their annual leave, of course, and the fact that they're going to take it is factored into the construction of the rota at the start. But when you look at a monitoring period, you can't know in advance, or you can't readily anticipate, and indeed shouldn't do, whether you're going to have one person on annual leave for 1 day, or whether you're going to have someone who's actually got a whole week off, and whether, therefore, in that particular week, the remaining staff have to pick up the strain in relation to that absence. But the reason that they can do that is because they know that the shifts have been organised in a way which means that they will be able to take annual leave in due course. So it's the fact that the rota has to be a self-contained entity which allows for a certain level of annual leave, but no one knows exactly how much, because it doesn't have to be taken in a particular 4-month period, but over the course of the year. That there's likely to be a level of illness, but who knows what. But it's been constructed to anticipate a certain level of absence. And that if they're in a predictable and normal way across the 4-month period that takes place, then everyone is going to get their natural breaks across the course of the rota. But the reason that you're feeding in substituted periods is to factor in that that person is on an unpredicted point of annual leave. And so you're more likely to get the remaining people perhaps unable to take their natural breaks, but you need to factor in the fact that someone is on an expected work shift but not actually working, so that you're getting a counterbalance to the pressure on those that remain, to those that are not there, because the shift has been designed to anticipate that. It is, without question, a theoretical construct. It is counterintuitive to people who are used to dealing with set rotas where you can bring in staff, temps, people from other areas to cover shifts. But we're talking about a staffing environment which is constructed on a fixed number of people over a fixed period, and has to be designed, constructed is the word, at the beginning to anticipate all of these vicissitudes. And the process of monitoring is to try to ensure that there is a securing of a sufficient number of natural breaks, not 100%, but a sufficient number of natural breaks that it can be comfortably worked out, or assumed even, I don't mind that word, that the construct of the rota as a whole is satisfactory. And if it isn't, because there is such a level of non-compliance, then there will be a penalty to the trust, and there will be a windfall to the staff.
Thank you. I think you've dealt with my point, and that's probably a suitable point as it in which to break off.
Yes, and I hope that when we look at the documents tomorrow, so some of these points will become a little clearer, and the difficulties that trusts have to face in setting their rota periods.
You can't, of course, Mr. Leaper, anticipate exactly how talkative or troublesome we're going to be, but
I thought that the last 50 minutes would take about 10, so yes. I would hope to finish by lunchtime. That would be my...
Right. Thank you very much. So 10:30 tomorrow then.
Good tries.